Right then, ladies and gentlemen, this is huge. This is absolutely massive. This is not to be trifled with how big this is in terms of the potential to set a precedent moving forward with respect to Disney and also just, well, copyright laws in general. The Predator screenwriters, Jim and John Thomas, are suing Disney to recapture the rights. Now, there's a lot more to this story than just that as a headline. There's so much involved here. Now, Disney were one of the key reasons why copyright laws were extended in the way that they have been. They were the reason they were extended, right? Just trying to keep the mouse, trying to keep all of their original properties from falling into public domain. They are the reason that copyright laws have extended in the way that they are. Now, what the Predator screenwriters are doing, are essentially just following a standard legal process, which there are already precedents of. But because they're going up against Disney here, there's going to be an interesting balance to be struck. What's going to happen? Can Disney flip the precedent that's already occurred? Can Disney change things? This is huge. Absolutely massive. Don't underestimate how big this is. So let's dive into this. This is on The Hollywood Reporter. And I've got some other bits to go into as well. But I honestly cannot be stressed enough how big this is. So Jim and John Thomas says Disney's hold on the franchise expires this week. And Disney go to court for the first time on the copyright termination front. Because they were one of the reasons why it was extended in terms of public domain copyright. Now I wonder whether they're going to have enough power and sway to flip things. Oh, so interesting. So Jim and John Thomas, the brothers who wrote the 1987 action film Predator, have filed a lawsuit against Disney seeking confirmation of successfully recapturing rights to the franchise. Now meanwhile, Disney's 20th Century unit has filed its own suit against the Thomas brothers with the goal of retaining the rights. Interesting. It's interesting that they think they can do this, and it's interesting to see whether they actually can. Now, the Thomas brothers are seeking to exploit copyright law's termination provision. Now, I don't like the phrasing of that, exploit. They're not looking to exploit it. They are literally looking to do what copyright law allows them to do. It's not an exploitation of the law. It's working within the bounds of the law. But this is very telling in terms of who the Hollywood Reporter is backing. Exploit? No, it's not. They followed all legal process. All legal process. But mainstream media brown noses again for Disney. Take your tongue out Disney's arse, Hollywood Reporter. They're not exploiting anything. So no, they wish to follow copyright law's termination provision, which allows authors to cancel transfers after waiting a period of time, typically 35 years for newer works. Given the time frame, the studios are facing the prospect of losing franchise rights to many iconic works from the 1980s. And this has already happened. This has already happened. Clive Barker now has the rights back to Hellraiser. You also have the likes of, Friday the 13th. That's back with the original rights holders as well. Awaiting an appeal process, but yeah, there are quite a lot of precedents here already. Now, Predator, of course, starred Arnold Schwarzenegger and spawned 3 sequels, plus the spin-off movies Aliens vs. Predator. Reportedly, Disney has been eyeing a reboot with 10 Cloverfield Lane director Dan Trachtenberg at the helm. That's not reportedly, they absolutely are. They are now shooting... Predator 5 was pushed back one more week, and Skulls, which is Dan Trachtenberg's, is what it's being called anyway, is going to begin shooting in June this year, already, in Calgary, Canada. So it's ready to go. But again, that won't stop it. That will not stop the process that's occurring. Why? Because again, we already have a precedent for that. Hellraiser's Clive Barker. There was a new Hellraiser movie announced, David Goyer. It even had a director involved. It was a Hellraiser reboot, remake. Clive Barker swooped in, filed a lawsuit, got the rights back. Done. Literally done and dusted really, really quickly. So there's precedence for everything that's being set, like for everything that the Jim and John Thomas are going up against here. There's already a legal precedent. So I will be fascinated to see what Disney do. You cannot stress this enough. This is huge. The last time something like this happened with Disney, they managed to change public domain, copyright laws. So such plans by Disney may face an obstacle in the form of termination. According to the complaint, the effective termination date for their screenplay, originally titled Hunters, is April 17th, this Saturday. Now, Jim and John Thomas say they served a termination notice all the way back in 2016, and for 4.5 years heard no objection. Now, what comes next is not surprising, and is not something that I disagree. I firmly believe it, basically. So, as stated in their complaint, so they didn't hear anything for 4 years. Then, in early January of 2021, defendants' counsel unexpectedly contacted plaintiffs' counsel, contesting the termination notice as supposedly untimely, based on a theory that the 1986 grant of the screenplay underlying their Predator films allegedly qualified for the special delayed termination time window, which is for book publication grants. So they spent 4 years trying to figure out how to go around this. Well, 20th Century Fox would have spent a few years, and then Disney would have spent the other couple of years trying to figure it all out. It's not for even 4 years, it's 5 now, isn't it? And then Disney decided to pull this out their ass. Book publication grants. Just ridiculous. So in response, the Thomas brothers say they served alternative notices of termination with later effective termination dates. So again, following all legal process, being very, very lenient with it all, and that hasn't satisfied Disney, so the Thomas brothers are just going to court, and they're seeking a declaratory relief. So basically, court goes, yeah, no, you've lost the rights, Disney. Shove it up your whatever. Now, they're represented by Mark Toberoff. Now, this is important because Mark is basically a specialist in copyright termination and has represented the Friday the 13th writer in a court win pending appeal, and the complaint is below, which is crazy. So, precedent, good lawyer involved as well, understands what the process is, has won already. Within hours of filing by the Thomas brothers, Disney's 20th Century Division had its own lawsuit ready to go. They are so on it. They're so on it. They knew this. It's ridiculous. They spent 5 years procrastinating, and they leave it all to the last minute. And they do this to prolong the process. They do this all because as long as they file it, then they can start to proceed things ahead. It's still, it's in kind of legal uproar. They can still do stuff with it. So it's procrastination at its finest. While federal statutory copyright laws endows certain grantors, like defendants, the Thomas brothers, with copyright termination rights, such rights may only be exercised in accordance with the statute's requirements, including provisions delineating when termination notices may be served and when the termination of rights becomes effective, states 20th Century's complaint. Defendants' notices fail to comply with these statutory requirements and are invalid as a matter of law. I mean, that's pretty massive in terms of the statement that they're making there. Disney's 20th Century Studio is being represented by Star O'Melveny, litigator Daniel Petrocelli, whatever the bloody name is. About a decade ago, on behalf of Warner Brothers, Petrocelli fought Toberoff over the rights to Superman. And that case lasted for years and grew very nasty, with allegations that Toberoff had tortiously interfered with rights. And ultimately, Warner Brothers prevailed. But I don't think this is the same. So now the two are stepping back into the legal ring over Predator. 20th Century seeks a declaration pursuant to 28 U.S.C. 2201 that defendants' notices of termination are invalid. This action is necessary because defendants are improperly attempting to prematurely terminate 20th Century's rights to the Hunter's screenplay, at the very time that 20th Century is investing substantial time, money, and effort in developing another installment in its successful Predator franchise. Well, the last one lost money, so that could be pulled up in court, surely. And here it all is. Here it all is. So this is huge. Like, you cannot stress how big this is. It's massive. And I tell you what, I really do hope they lose. I do hope they lose. Now, this is different to my stance on Clive Barker retaining the rights to Hellraiser. Because he wanted it back just to sell him off again. Or just to sit on it. But that's a man who has actively lamented the franchise, actively worked against the franchise. Jim and John Thomas have done nothing like that. They've done nothing like that at all. So there's not a precedent to be had in my mind that they will just squander the rights again. I think that they will ultimately shop it back out. But I don't think that they hate the rights. I don't think they hate the franchise that they spawned. Whereas Clive Barker ultimately does, and is fairly evident. But Disney stepping into the ring is huge. It really is huge. And because there's precedents already to be had, it'll be a fascinating thing to see how this unfolds. So please do let me know what you think down below in the comment section. If you're new here, please do hit subscribe. I'd love to hear what you think. Cheers, guys. Take care.